tries to counter the claim of the plaintiff. So, for example, if Kashim, you sue me, when I'm replying, I'll also add mine, an independent claim within yours to respond and say, I'm also claiming from you this. And when you present it to court, the court will give you the first priority so that your claim can be ascertained before the claim of a plaintiff or a claimant. So it is an independent one. It is treated as independent and it's given a priority, a preference. When you go to the setup, you said about the setup?
Yes, setup. Distinguish between the two.
Now this one is not independent. This one is not independent. It is while you are responding, when you are replying, you also claim that if the plaintiff or the claimant is asking for 500,000, your responses, your verbiage, you will say, if you are asking 500,000, you also owe me 300,000. So I'm willing to give you the balance. That's what I understand by the counterclaim and a set-off. Set-off reduces the liability. Yes, you are the meat. That liability is low than what you claim. Well, a counterclaim, be listened first.
Thank you for that. The other people, what do you say about, are we in agreement as a correct version? Anyone wants to chip in and give something more? Ask. I can see Victor says it's okay.
Yes, maybe it was a common claim and counterclaim.
Okay.
To
I can see Audit also said that it's okay. Huh?
I just want to add on claim and counterclaim.
Claim and set off. Counterclaim and set off.
Okay, thank you.
You can add. Because claim ile complaint alafu counterclaim ile defendant anakuja na claim fresh. Only people you can add.
I think what also sets apart a set-off and a counterclaim is that a set-off, you have to claim it first before you file your counterclaim. Because the set-off is like a shield for defense. So you cannot counterclaim before you file your set-off. Then you can do your counterclaim and then set-off. It has to be the other way around. And a set-off is independent of the defense, meaning it's answered separately, as opposed to what Charles was saying. So the counterclaim, of course, is a suit within the defense, yes, but a set-off is handled separately from the defense of the counterclaim.
Okay. Yeah, I agree with what you guys have said. Basically, a set-off acts like a shield, like the example that Charles gave us. I owe you, all right, but you also owe me. You see, and then trying to juggle between many different tabs here and they're getting lost. Counterclaim, you're bringing another suit against the plaintiff. I can see an example here. If A sues B for cash $1 million and B says I already owe 30. If A sues B for cash $1 million and B says A already owes B cash 300,000. B may plead set off to reduce A's claim of 2 to 700,000. If B also claims A breached a different contract and owes B cash 2 million, that's a counterclaim. But counterclaim na sasa nimeona si nyingi sana. Wacha tuende kwa hii ingine. What is a third party notice tuliona jana. What is a third party notice? Maybe for the interest of those who were not here yesterday, what is a third party notice? Anyone wants to try? You can say what we said yesterday. A third party notice, you can know a third party notice from your understanding of a counterclaim. A counterclaim is directed towards the plaintiff. A counterclaim, the defendant claims something against the plaintiff. But now if it's a third party notice, you are doing the same thing, but not directed towards the plaintiff, but directed towards a third party. So the defendant, and I remember yesterday someone gave an example. If you are involved in an accident and then there's a trail, you hit the person that is in front of you, and then that person sues you because you hit him. You can claim that you hit him because you were also hit from behind. So you put the blame on the person that hit you from behind, and then you also hit the person who is ahead of you. I don't know if that drives the point home. But you say it was already put the answers to the group. For us to write we can go to what is the purpose of a third party proceeding. Third party proceeding. What is the purpose for third party proceeding? Victor, you can try that.
Yes, the purpose is to seek indemnity or contribution from the third party. If you're the defendant that you want to serve this third party notice.
Yes. Who wants to add something to that? Who wants to add something to that?
I can try.
I'm adding that.
Yeah.
Charles, you can go ahead.
Yeah.
I wanted to say let me ask, but let me now that, for example, I'm a contractor. I can sue my subcontractor for not completing his or her work. So he has to come in to take a fraction of the liability.
Mm-hmm.
For defective, maybe construction work. And the effect is that the court now will determine the share of liability between the defendant and the third party within the same suit, so that to avoid separate lawsuits, and also it is important to promote efficient resolution of disputes. It saves the court's time and expense, and to reduce the burden in the court system. This one is very important. There is a friend of mine who sold his matatu. He bought from Mombasa about 3.9 million and sold it to someone else. And higher purchase. And then now before he had completed paying, he sold it to another friend. That another friend started to use it, but defaulted to pay the higher purchase kwa muhindi. Now that vitu zikaenda, wawili wakapelekana kotini, small claims, but akaomba pesa si 1 million. You know, ignorance is a disease. I told this friend, now you are sued by that friend of yours, claiming from you. He has been using the car. So are you going to bear the liability plus the interest of higher purchase huko Mombasa kwa Muhindi? How will you carry this load? Nikamwambia, the third party you can add here so that you can share the liability tu. Hiyo matatu ilikuwa imechange hands mara tatu na imetumika. So this is a practical scenario that the third party should come in to assist to offset some of the liabilities.
Okay. Thank you for that. Anyone else to add apart from what Santa said? Felipe, what did you want to say?
Also, it allows for the third party to be bound by what the court says between the defendant and the plaintiff. And then also it enables determination of issues between the defendant and third party as soon as possible to determine a main cause of action. And then I think finally, which was the last one that I remember, it was to prevent multiplicity or filing of different claims, to prevent embarrassment of the courts. In those three, yeah.
Yeah. Now, what comes to mind? You know, you might be asked in light of your answers, how that is different from representative suit. You know, where representative suit, we saw representative suit earlier, where parties agree that one of parties to a suit are many, like where there's an accident and everyone has a cause of action, but then you appoint one person to go and represent you in the suit. So that you say, for example, Cheriot Victor and 38 others. Those 38 others decide that Cheriot will be the one who prosecutes. What will be the difference between that and in a third party notice, a third party proceedings? How would you put the difference?
Representative suit, you have to have a number of people. So it really gives let me say 50 people. It has to have a similar cause of action or a similar let me say cause of action and a similar remedy. Because at any point, if the remedy is different or the cause of action is different, one will have to file a separate suit for that particular matter. You might have the same parties, but different cause of action and different remedies. So that's what makes it different from third party notice. Third party proceedings, that's the word. Yeah.
Okay. Anyone wants to add something? Ndiwa Oliver, karibu.
Thank you very
Ndiwa
much.
Oliver, I want to ask you the next question, Ndiwa. Can I go? Distinguish between striking out a pleading and dismissing a suit. That is yours, Oliver. Distinguish between striking out a suit and striking out. Sorry, what did I say? I said distinguish between striking out a pleading and dismissing a suit. Would you try?
If I may try, I've just joined a few minutes ago and I didn't know there will be a discussion today. Let me just.
It's okay.
Then
you can also pass.
Sure.
Yeah, you can try. You can try.
You said striking out a suit and.
Yes, distinguish between striking out a pleading and dismissing a suit?
First of all, dismissing of a suit is the point whereby a judge or a magistrate deems it that the suit is not, let's say, for example, on matters jurisdiction, the suit has been filed in the wrong jurisdiction. The court doesn't have jurisdiction to handle that matter. Then the court will dismiss that suit in that particular court. Or at the event, you filed a suit which, for example, like you filed a children matter in a constitutional division, for example, and the court cannot hear or determine that matter in the said court that you filed, then the court can end up dismiss that suit, or it can transfer the suit, if I may. Then striking out a pleading is the event whereby you filed the wrong pleading, or you filed the pleading after the closure of time of filing of pleadings. Then the court will strike that pleading, and you not maybe sought leave from the court. The court will be in a position to strike out that particular pleading.
Okay. Thank you. I can see Cheriot's hand is up. And Deep also. So let us start with Cheriot. Cheriot, you can add something. Thank you, Oliver.
Okay, let me. Yes. I don't know if you're able to hear what I'm saying.
Yes, we are able to hear.
Okay, let me start with striking out bleeding. By first saying that a pleading is a formal statement of a party case. And it's normally include the claims, defense, counterclaim, or any other form of reply to the court. So the legal provision for striking out the pleading are found in Order 2, Rule 15. If I'm not wrong, around there. So that rule gives us the grounds which a pleading may be struck out. One of them is where the pleading failed to disclose the cause of action or defense. That's the first one. The second one is if that pleading may prejudice, if it may embarrass or delay the fair trial of the action. Third one is if that pleading is scandalous, frivolous, or vexatious, may be struck out. Then, when we come to dismissing a suit, so we want to differentiate between the two. Dismissal of a suit means that the court terminates the entire course of action. So some of the reason why the court may terminate a suit, the suit include non-appearance. That's Order 12. The second one is it may dismiss a suit after hearing in the situation whereby the plaintiff failed to prove the claim after the full hearing. So the court may decide to dismiss that suit. Under Order 17, being Rule 1 or 2, somewhere there, of the Civil Procedure Rule, court may dismiss a suit where the plaintiff fails to take the step in prosecuting his suit. That's what is normally called dismissal for the want of prosecution. So those are the differences which I can bring before you tonight.
Okay, thank you. Thank you for that. We'll see in the end. Odipo, you also wanted to say something?
Maybe just to differentiate it simply, for dismissal is an issue with procedure, and then for striking out is an issue with the pleadings of the case. So procedure can be jurisdiction, it can be let me think. Okay, let me say in terms of procedure, yes, you're lacking a particular procedure in your pleadings. For striking out is you're lacking cause or on the face of the document, there's something that there's not enough evidence. So those are they're not what is the opposite of procedural? There's an opposite. But yeah, striking out is the opposite of procedural. So dismissal is based on procedure and striking out is based on the opposite of procedure. Yeah. That is easier to
Okay, thank you for that. Victor, you have something to say?
Yes, my points were to bring maybe the practice part of it. If you mention striking out of a suit, these were, as Victor has directly guided us, and Madam Odipo, is that you are striking out a document maybe because it has not disclosed a cause of action, it is frivolous, scandalous, or no defense. Okay, that is one. When it comes to the dismissal part, the order 17 of the civil procedure rules dictate that there are two grounds where you can apply for dismissal. The court can issue a notice to show cause why a matter should not be dismissed for want of prosecution. If the matter has stayed for 1 year or it is still stalling and you are not appearing, you will receive this notice. Then number two situation is where I'm marrying with practice. Hearing, failure to attend a hearing, either party, sana the plaintiff, that matter will be dismissed. And the key difference between the two is that if your matter is struck out, you can refile. If your matter is dismissed, you must set aside that ruling or judgment because it will be subjected to res judicata. Unaona? You can't refile something that has been dismissed because I've got to agree. Another key takeaway is about where you are comparing between representative suit and third party. The key difference between the two is where you are seeking for third party, you must seek leave. Okay, and it is maybe up of with equal strict timelines within 14 days. Ukome serve the third party notice. Now that is the difference between third party proceedings to representative suit, because in representative suits the mandatory nature of it is where you must notify the parties, as Madam Odipo had previously told us. So those are the practicability aspects that I'm bringing on board when it comes to this discussion. Thank you.
Okay, thanks for that. I also want to bring to your attention what we saw yesterday. You remember this question? We did ask this question yesterday as well, and we said briefly, in very brief terms, what we said is that you talk about striking out a pleading when there is a defect. When there's a defect on the face of the record, and because of that defect, that suit cannot go on. You see, and then it has to be, and then to be struck out, and that defect can be, you can mend that defect, you can cure that defect, and go back again with that same suit. But when you're talking about dismissing a suit, that suit has been finalized. The only option you have is to appeal. You see, you would be constrained by res judicata, just like Victor has said. The whole suit has been heard and determined. Res judicata means heard and determined. So a suit is dismissed when it has been heard, you have adduced evidence, but evidence was not sufficient to support your claim, and then it is dismissed. So you cannot go back with it again. It has reached final determination. You have failed to prove your case or your claim. That is what we saw yesterday. I've noticed that there are a few differences here and there, but we are going to put, like we agreed yesterday, we are going to put these answers, the answers that have been verified and which we know to be true. We're going to put them in writing, and then we share in the group for purposes of revision, so that people can just make reference and revise and refresh their memory. So I think I'll do that later. Since I'm chairing today, I think I'll do that with all the questions that we're going to do today. I'll go and research and put everything in the group. So we go to the next question. So this question, the next question, I want to direct this question to Stephen. Stephen, are you there?
Yes, but
are you now okay?
Me, I'm listening, but just proceed. I have a deadline. I have a deadline that I'm trying to work on.
Okay, no problem. Just go on.
I can take this.
You can take it, Charles. I want to give it to someone who has not spoken. I want to go around. I want us to be going round and round so that nobody falls asleep. Yeah? Let me throw this question towards Elizabeth. Elizabeth, are you there?
I'm here, but I'm having 2 meetings.
Oh, okay.
Right? But I'm listening.
Okay, Elizabeth, no problem. Then I'll throw it to you, Charles. I'll throw this next question to you. What is the purpose of an affidavit of service? What is the purpose of an affidavit of service? Yes?
It's also called the certificate of service. It is sworn an advocate or a process server to declare or to give a statement under oath that he has done effective service.
Okay.
Either upon the respondents or upon the plaintiff. And the contents are just to swear that he has served maybe the plaint and accompanying documents. It is a proof that service was done, and there's no excuse that can be brought before the court, because I know once there is no proof, even if if you don't swear this one, you have not served. You just did delivery, and delivery is not allowed in court. You cannot testify that you really did service. So the service can be done by one, an advocate, two, process server registered, and there was a certificate, and if you are representing yourself, you can swear an affidavit that how you did service. That is it. And you can file it in the court. You don't just write it and keep it at home. You file it in court. You upload it in the CTF and you pay for it. And the moment you have not paid for it and your file, you start is not filing. Once you pay for it, it's about 100 shillings or 50.
Yes. Is it midnight?
I can't hear you.
Can you hear me, guys? Can you hear me? Can I be heard?
Now we hear you.
Can I be heard?
I hear you.
Oh.
Yes.
My internet, I think my news is acting up. Now you can hear me. Now you can hear me well.
Yes.
Okay. I thought it was yours, chance. So it was mine. Eh? I thought it was it was your network, but I think it was mine.
Mm.
Okay,
There are many
so
friends who
see here.
about it.
Okay, so I can see here, Victor has something to say. Victor,
We are two.
Victor, you want to add something to what Chance has said? Huh?
You can use surnames.
Usernames because you have Victors.
Oh. Okay, Ngaruya.
Yes, thank you. While Charles is in his feet, I wanted to confirm something, whether he understands the procedure of service, because he's responding to an affidavit of service. So, Mr. Charles, you are a director, not you are a director, you are a process server, and you have served a director of a company via WhatsApp. Is that sufficient service?
I serve the director of a company.
Via WhatsApp. And it is his number. You have even proved by annexing an M-Pesa one message.
As it stands, electronic service is allowed. The procedure rules, there are amendments, especially in the, I'm sure, of procedure rules for ELRC codes. That is electronic service, so long as you can prove to show that the number you served is the person who was supposed to be served.
Okay. I was testing something, but it looks like I'm giving you an answer to it. There is a certain aspect that I wanted to see. So basically, serving a director of a company through electronic means, is it a violation of the general norm that you must serve the company physically from its registered offices? That's the point that I wanted.
As long as you serve the right persons, you serve them the right persons. Sometimes some companies don't have registered offices. What if now you don't find the offices? They have moved and they have not said where they are located. But the number you are having is reachable and you have confirmed. You swear that this is truly his number or their numbers, and I couldn't find the officers, and this is what I did.
Have you heard of
Charles, let me ask you.
Chariot, I'm on my feet. Okay.
Let me ask you.
I had that last one.
Charles, before that last one, what are the requirements for the registration of a company? Because
I think
you must have
what
the
we do.
office.
Okay, wait. What we do if
Companies don't have these offices. Some companies don't have physical offices, or if they do, if they have moved, and they have not given
any. I just direct you to go and look at the requirement for the registration of a company, because that's some of the requirement for a company to be registered.
Yeah, I know that one is there. So the question was saying, what is that? It has not given the process, but it is asking, what is the purpose of affidavit of service? Now, if I move next level to answer to handle the extension that you are giving, I can move on and do that.
Last one, because Chariot had interrupted my feet. Okay. Mr. Charles, do you know of what we call a registered service via registered postal address?
Yeah, postal address. Yes.
I think what we do, because if we are going to get mixed up, if we start if we let us ask one and exhaust that one. After exhausting that one, we ask another one. We are going to get lost if we're asking a question and another one and another one. without the initial ones being answered. You asked this question: serving a director of a company via WhatsApp is valid service. Let us start with that and see what other people think. Because Chance has given a response to it. I want to see if any other person has something to add to it. And then if we are done with that, we can go to the next question now, isn't it? And Cheriot, you wanted to say something about that specific question that Ngaruya asked. Cheriot.
Yes.
Just a quick one to do. After Chariot, can you give me a chance? So, after Chariot, can you give me a chance?
Okay, I will.
Ngaruya asked a question on the service of director through WhatsApp. There's amendment was introduced to Order 5 Rule 22C. Maybe will that answer you, Ngaruya?
Yes, that is sufficient.
Okay.
What does it say?
The Rule 25, Rule 5, Order 5, Rule 22C, that talk about the use of WhatsApp being
for service.
Used for the service. That's whereby you have the sender sending a service through WhatsApp, then the delivery receipts is confirmed, and the person who is serving have to file the affidavit of service by attaching the proof of that service being received.
And okay, that is clear. But what would be the effectiveness of serving a director and not the company? Because I think the other aspect that Ngaruya raised is, or is it Charles? You need to be serving a company. You know, a director in a company, a director is a different person from the company. A director is a different legal person from the company.
Now, you know, a director is a recognized person upon whom the service on the company may be affected. So, again, on that one, you can look at Order 5, Rule 3A of the Civil Procedure.
Order 5, Rule 3A.
Yes.
Okay. I'll go through these rules. I'll go through Order 5, Rule 22C, like you've mentioned, Cheriot, and also Order 5, Rule 3A, and then I'll come up with a concrete answer and share. So we can let us hear Elizabeth, and after that we'll hear Odipo. Oh, yes, Elizabeth.
Yes, so I wanted to address your mambo ya WhatsApp, and yes, electronically it's allowed, hiyo iko sawa, it's acceptable, that is. However, you know, in WhatsApp, if you send me a message, KD, and if I open it, there is the blue tick.
Yeah.
So if there is no blue tick, then ikiwa great imekuanisha sijafungua, then I can argue that I have not seen it. That is something that's an argument I want to put across. Therefore, I think an email would suffice or would be stronger than a great WhatsApp message. Okay? So that is the two things that I wanted to put across. Yes. Otherwise, this was sour. But I just wanted us to think, and in such scenario, if I put across an argument, I say it's creative, I did not see it. Yes.
Okay. Odipo, you want to say something? You want to add to it?
Yeah, let me say I concur with Victor. I believe that's Cheriot, because a company is a separate entity. So with the person that they're serving, is it the company secretary, the director, or the principal officer? It's not served on the company. Even in company law, any matter is sued in the company's name, but you're suing a director. It is a person, not the company itself. Then for the electronic service, even if you're serving and you don't see the blue ticks, there's a way of confirming if you have seen a message, which is going to information and looking at seen or not seen. So that's the other way. But ideally, what Cheriot said is right. It is served on the company secretary, a director, or a principal officer, not on the company itself.
Thank you for that. This is Jemima. Asante.
Okay.
Thank you.
Galia,
So,
you want to add?
question.
Sorry?
Kashem, sorry for interrupting.
Yes.
I didn't raise my hand. The original question was the purpose of certificate or affidavit of service. And then my friend asked
Yes.
the father, how can you have a director? He not say the directors, just he picked out one, the position of a director. And maybe particularly, maybe he had in mind that he only wanted to serve one director. So he did not disclose whether it is a company to be served or a director as a person. Maybe you are serving him as a person, maybe a different thing. You are not suing the company, you are not interested in the company, but a person or holding the position of a director. But if we follow the procedures of company law, now you have to serve 3 directors so that it is effective, or plus the secretary of that company.
But in line with what Jemima was saying, Jemima was saying that if you want to serve a company, it would be valid service if you served the director of that company, if you served the company secretary, and if you served what was the other third option? Remember,
The principal officer.
the principal officer.
Yeah, or you can send it to a registered office. So also the only 4 times that you'd be those are the only 4 ways you'd be able to serve: the company secretary, a director, principal officer, or a registered office by post.
Yeah, and there's this issue that Mugunde Charles is raising. You know, you might want to serve the director on the individual capacity, not as the director of a company. But I think then if you want to sue the director, then if you served them, it will not be contentious. If you can be able to show that you have served, that the person that you have served is the one that you are suing, it will only be contentious if you are serving a director on behalf of a company. But I think that is valid. I also think it would be valid. Jemima, you want to add something?
I think if you're serving an individual, regardless of them being a director or not, it's just service to an individual. But if you're serving of the purposes of the company, then it's serving to a director. Because if I'm suing you, KD, you could be the CEO of whichever company that you are, or you're the director of whichever company that you are. But if I'm suing you in your personal capacity, and whatever I'm suing you on is not party to whatever the company's objectives or whatever it is the company handles. I cannot sue you in the capacity of I'm suing you as a director of a company. I'll just sue you as KD. So I think that is where the difference comes in.
I also think the same. I don't know if that answers Mugunde Charles.
Yeah, that is all right. Because the question framer just asked the direct, the person of a director, not a company. So the company was not in mind. But he has the answer. That we were looking for a director, regardless of whether it's a director or not. But that is the name we refer to as a director, by not mentioning the company. So if I want to serve the company, there are particular procedures, and if I'm serving a personality, an individual, who could be a director of many other companies, or who could be a servant somewhere, a civil servant. Personal, that is personal service. But if it is a company, it's an reference for that.
Okay, okay. I think we've tried to dig around that and that's a very probable question, Victor. I think that Garuya, I think that's a very probable question. You can come face to face with that question.
Sorry, KD. Yeah. What was our conclusion on service? Do you serve? Whom should you serve? If you serve a director, have you served the company?
Yes, that is the general conclusion. If you serve the director, you have served the company.
Yes, if you look at the company law, there is. Okay, I wanted to add something. If you look at the company law or the company act, there is something called the officers, the officers of the company, and directors are one of the officers of the company. Another officers of the company is the company secretary. Although not all companies have got a company secretary, but it is mandated that all the public companies must have a secretary. Yeah? So when you talk about the public companies, if you're talking about, like, for example, the government ministry, you serve the PS, that's a accounting officer for the ministry, isn't it? If you are serving now, like the government itself, you serve the office of the AG, isn't it? Okay, I've just broadened it just to move away from the company so that we can understand. A company in itself, as much as is a legal personality, Article 266 of the Constitution, a company is supported by the natural person, and that's why you can't form a company without a natural person. And that's why even when you sue a company, who acts on behalf of the company? It is a natural person. So you need to ask yourself, which is the ideal natural person to serve in this particular case when you're serving the company. If you ask yourself that question, then remember the Company Act of 2015 has been reviewed, especially after COVID or during COVID. And that's why you find all these electronic ways of service, the WhatsApp, the email, have now been included. So there before, there was the issues of looking for the office, registered office, the postal office, registered mail, and what have you. But the law has been relaxed to accommodate the development that took place, especially so many things changed with COVID-19. I just wanted to wade into that discussion, and I hope that is clear. Thank you.
Yeah, thanks. Welcome. Garuya, Victor, you wanted to say something?
Just a small, and then we close off the issue of service. Mr. Waweru, what if I'm serving a director now through his email? Will the court recognize that service as the first time? I'm telling to the court, hey, look, I instituted this suit, I served the pleadings, everything to this director. Now give me another mention date.
I tend to think if you are able to demonstrate that the email is used in the course of duty, then that is the right service.
We don't require a leave of court because it's part of substituted service.
No.
Okay. Sorry, go ahead, Kasim.
I might also chip in. I know that you might want to prove that the email you sent the service to is an email that you've ordinarily used for communication with that person. But maybe somebody else. If you can show that, then you have effected. Then your service has been successfully effected. But people, you want to add to that?
I think maybe Victor is trying to land his point on substituted service. But as long as you can confirm, if there's proof of confirmation of receipt, you can definitely serve the defendant through an email. Because for substituted service, it is a very special circumstance where you have not been able to get an email, a phone number, a physical location, a post service, or even whichever directories you're trying to serve. And substitute because also, for electronic service, there's also, you can use what do you call these things, courier services. So if you're not able to use all of these services that are afforded to you, then you can apply for substituted service. But as long as you can confirm that you have sent an email and they have confirmed receipt, you have mobile communication and they have confirmed receipt, or you have submitted through an international registered carrier, it's called a courier. Let's say by a tracking record or something, you can record that as part of your affidavit of service. Substituted service only comes when all of these things have failed. Then you can file for substituted service to the chamber summons. Yeah.
Mm-hmm. Yeah, I thought so too. Substituted service mainly, you go for it if now you want to use the paper, for example, you want to advertise, or you want to stick those things somewhere you think they may be able to see. Mugunde Charles, you wanted to add something?
Yes. Now, all the answers you have provided are correct. And just to tell you, by practice, I've been serving by email. And once you serve by email, you get a screenshot. That screenshot, you attach it with the affidavit of service to prove that on this particular hour, if you can serve maybe at any time, it gives you time, they call it time word, signature. Yeah, it tells you the screenshot of the email delivered. It tells you the time it was delivered. And then in the affidavit of service, you declare that there was no return. That mail, it was no delivery, all the deliveries were made, no return report. Then you print that report, you attach it, that is service. It has been accepted whenever I've been representing myself in court. So you don't just say swear an affidavit without showing that there's a screenshot that you sent. And by the email, the same email, you tell them by a copy of this email you have been duly served in accordance with the applicable rules of the service. And then you tell them kindly acknowledge receipt. You complete that way. Kindly acknowledge receipt, even if they don't acknowledge, but they normally acknowledge. That is service.
Okay.
If the judge sees that, service was done.
Okay. Okay, thanks. Allow me to ask the next question, and I want to shoot this to Odipo. I'll shoot this question to you. Can I go?
Yes, go ahead.
The question reads, distinguish between summary judgment and default judgment.
Summary judgment is entered when the plaintiff decides to withdraw the matter and request for summary. Default is entered in absence of, so if the defendant fails to enter appearance. So that's the difference between a summary judgment and a default judgment.
Sorry, would you say again? I was struggling to. Yeah.
I'm trying to make it as simple as possible. A summary judgment is where the defendant has entered appearance, but the plaintiff requests for the case like to be closed.
Okay.
So in that, the courts will give a summary judgment on the matter. If the plaintiff does not want to go to trial, will get a summary judgment. For a default judgment, it happens when a defendant fails to enter appearance. Therefore, in default of him entering appearance, let me not say he, in default of them not entering appearance, the plaintiff can request for a judgment, and that's what is a default judgment. So for one, the plaintiff does not want to go to trial, and for the other, the defendant has failed to enter appearance. That is the difference.
Okay. Okay, thank you for that. Anyone who wants to add something to what Jemima has said? Anyone who has a view? Anyone who has a view on that? Distinguish between summary judgment and default judgment. Anybody? Okay, Ngaruya, Victor.
Okay, for the two, I can say default judgment happens when the defendant has not entered appearance and does not file any defense. For the other hand, summary judgment is where the defense that has been filed by the defendant raises no triable issue, or it is a sham to defeat justice. So the other key difference between the two again is where you are talking about when it comes to the default judgment, you will be given a default judgment on the liquidated sums. But if they are unliquidated sums, you must go for formal proof hearing. Okay, so that you'll be given the default judgment, even if the defendant is not available. For the summary judgment, it will appear to be the final judgment and the court is satisfied that there is no defense arising from the same, and it is a proper judgment on its own. Yeah.
Okay. Thank you for that. Anybody else wants to chip in? When you're told to distinguish between summary judgment and default judgment, I think what you said is I can also align myself with that. Summary judgment, where there is no real defense or no genuine tribal issue. There is no genuine tribal issue. In summary judgment, they consider the merit of the case on affidavit.
Okay. KD, I have a question.
Yes.
Just a quick one.
Yes.
For your summary, is it the plaintiff that apply for summary judgment? Is it by application by the plaintiff? It's just by the court discretion, nary power, waki established that there is no legal grounds and there is no defense?
Wame consider both pleadings, ya plaintiff na defendant. Because summary judgment wame consider position ya plaintiff na defendant. Yeah, and then now they are arriving at a conclusion. So when having considered both, wanaona there is no real, hakuna kitu iko triable hapo. Hakuna kitu iko contentious hapo.
Kwa hivyo, kwa summary judgment, pleading that with after the summary judgment, that the issue can be considered as res judicata, right?
Yeah. And who can apply? You asked specifically who can apply. The plaintiff can apply. The defendant can also apply. Either.
Okay,
I don't know.
Yes.
I can say this has Arnold. Okay, Arnold, do you want to add to it?
Just some clarification.
You're welcome, Elizabeth.
Just some clarification, because in summary judgment, both sides have filed their argument. Even they get it right, both sides have filed their argument. Simple.
Yes, both sides have filed. Yes.
Maybe the court find is not necessarily for a full trial. Is that the case?
Yeah, they don't necessarily go for a full trial, but they consider the merits of the case based on what you have, based on the pleadings.
Yeah, then they say there is no necessity for a full trial.
Yes.
Then they do a summary judgment.
Yes. And on the other hand, default judgment is where maybe the plaintiff went to court and then the defendant failed to appear and then the plaintiff applied for default judgment. You see the difference?
Yeah, because maybe the defendant failed to appear in court or to file the defense. Yeah.
Yes, precisely.
Exactly.
Okay. Let us hear Victor Ngaruya. You want to say something?
Yes, Kashem, there is a small misconception that you have when it comes to the court's inherent power to look into the pleadings. Remember, that is a reserve of order 2, where the court will say, this plaint does not disclose any reasonable cause of action. Let me strike it out. No, that is an inherent power. But when it comes to some summary judgment, are you sure that the court can award summary judgment by its own motion? Okay. See, it must fall under a certain application, because only on a party's application will this judgment be applied, in my view. That is in my view. And Order 36, yes.
And we have seen that either the plaintiff or the defendant can apply to court to give a summary judgment, either of them. That's the same question that Elizabeth had asked. Order 32, you have it. You said order?
Order 36.
Order 36, you have it.
Yes.
Can you read?
Let me open it. I'm reading from my notes. Let me see. Order 36. Civil procedure.
Okay.
Because I believe the court will refrain. Okay.
As you find it, let us hear what Charles has to say. Charles Mugunde.
Yes,
you can find it, Victor. I'll come back to you.
We call when on the court's own motion, they call it suomoto.
Suomoto, yes.
Suomoto. Now, when these are jargons, now actually, while you are dealing with the case, maybe during the hearing, you can raise a motion. You can raise an application orally, a very brief one, that my lordship, your lordship, they have not denied on maybe paragraph 5 to 10 of my plaint. They have not denied anything. They have admitted. Give me a summary judgment on those, and then we remain with the other arguments. So you can have a summary judgment haraka sana, even before on those facts that have been admitted. So
can I also,
our
sorry. Oh, sorry.
Continue.
Finish. I wanted to wait into the discussion, But after you have finished,
yes, I'll give you an opportunity also, Stephen. I don't know if Victor has gotten his hands on Rule 36. Garuya, Victor.
Yes, I've found the same.
Ebu read.
Okay, I can read. Order 36 summary procedure. 1. Summary judgment order 36 rule 1. In all suits where a plaintiff seeks judgment for 1. A liquidated demand with or without interest, or the recovery of land with or without a claim for rent or misny profits by a landlord from a tenant whose term has expired or been determined by notice to quit, or been forfeited for non-payment of rent or for breach of covenant, or against persons claiming under such tenant, or against a trespasser, where the defendant has appeared but not filed a defense, the plaintiff may apply for judgment for the amount claimed, okay, the liquidated demand, or part thereof, and interest, or for the recovery of the land or rent or mean profits. 2. The application shall be supported by an affidavit, either of the plaintiff or of some other person who can swear positively to the facts verifying the cause of action and any amount claimed. 3. sufficient notice of the application shall be given to the defendants, which notice shall in no case be less than 7 days. So this is the provision that I'm saying you cannot use suo motu for the court to grant this summary judgment.
Okay.
Yeah, that was my argument.
Yeah, you described some of the scenarios that we were looking at, and then were you going to say something?
Yes, I wanted to say that when you talk about civil litigation, that is under civil procedure rule, and I think my brother has led it. And you talk about summary judgment and default judgment. First of all, both, underline the word both, they are mechanism used by a plaintiff to win a case quickly without going through a full trial. So both of the mechanisms are used by who? By the plaintiff.
Before you proceed, okay.
Let me finish, Kashem, please.
Okay,
However, they are triggered by entirely different actions or failure by the defendant. So both of them are the failure of the defendant. And when we talk about the primary difference between the two, let me walk you through the two differences. I want to compare the two. So we have the features, summary judgment, and default judgment. Let's first of all look at what triggered the triggering event. When you talk about summary judgment, the defendant files a defense, but it contains no legal substance or triable issues. So meaning that you took the defendant to the court, but their defendant, the defense they filed, it contained no legal substance or triable issues. What about on the other side on triggering event? Default judgment. The defendant failed to act. And I think if you have said that, failed to file an appearance or defense within the required timeline. So, doctrine of rights here. The default judgment here, the defense have failed to act. In terms of the governing law, we have talked about in summary judgment is Order 36 of the Civil Procedure Rule. If you look at the summary, default judgment is Order 10 of the Civil Procedure Rule. What about the Q4 argument? In summary judgment, the defender has no real defense. Basically what you're talking about. And a full trial would be a waste of time. So he has no full. That's why you see, look at his defense. On the other side of the default, the defendant has conceded the claim. He has conceded the claim through their total silence or absence. And I think yesterday we looked at the case of Remy case, the one for the car accident. The defendant has conceded the claim through their total silence or absence. The other one is the court hearing. I think we have talked also of court hearing. This one, the summary judgment require a formal contested court hearing. It's a formal and contested court hearing. And in that court hearing, both sides argue their position. Only that it is defective on the side of defense. But when you talk about default, often granted automatically by the court without formal hearing. I think there's somebody who has mentioned about that. In straightforward debt claims, then setting aside, let's look at the issues of setting aside, very difficult to overturn in the summary judgment. You can't overturn it. The defendant had their day in court to argue their defense. On the other side, can be set aside. Why? If the defendant proves a good reason for the delay and has a defense on the merits. I will try to figure out that, the setting aside. What do you understand by setting aside? We have said in a summary, whatever a judgment, it is very difficult to overturn as the defendant had their duty day in court to argue their defense. But on the other side, we are saying can be set aside if the defendant proves a good reason for the delay and has a defense on the merit. If you can differentiate the two, you should be good to go. I think all the others are clear.
Yeah. Now, what I wanted to ask, the specific instances where a defendant can ask for summary judgment. There's a specific instance like where there's a counterclaim. A defendant is allowed to enter another can respond by way of a counterclaim instead of a defense. A defendant can respond to a counterclaim and not a defense. In such instances, a defendant will seek summary judgment. You mentioned that this is only reserved. It is only reserved for the plaintiff and not the defendant. But that is one of the circumstances when a defendant can ask for summary judgment. I think maybe other people can also. I saw Jemima, you want to keep in?
Yeah, let me add. So, if you're going to apply for summary judgment, this is after the defense, after appearance, but before defense. So, at no point will they be able to file a counterclaim. Let me explain it better. You see, there are three limbs of a summary judgment. Is there a defense? Is the defense real? Or is there conditional or unconditional review? So, if the court finds some arguable defense, even if it's clean, it may give the defendant a conditional leave to defend requiring payment to court or provide security. So, at no point will they be able to even file a counterclaim yet, because you're not even going to trial. So
yes, madam. Oh, sorry. I'm sorry.
Yes. Proceed, Steven.
Because what they are saying, when you talk about the conduct of the defendant, when you talk about summary judgment, the defendant is active. But when you talk about default judgment, the defendant is completely passive. And you find like in summary judgment, the defendant is not sitting on his right. And in most cases, what happens? Let's say you have been taken to court and you are being demanded 1 million Kenya shillings. Or you are being evicted from your piece of land because of one or two reasons. Na unataka kujipanga. The best option here is to remain active, to buy time. But let's say you have no interest on the matter and you know this matter, no matter how you plead, you don't want to waste your money, you can be completely passive. And that's why you say in summary judgment, the defendant is acting, they have interest, they have entered an appearance and they have filed a formal defense. However, their defense is a mere sham, a boilerplate denial, or a tactic to delay the case. What we are saying here, the plaintiff asked the court to look past the paperwork and give judgment because the defendant has no chance of winning. But remember here, the defendant is acting. But in this default judgment, the defendant is completely passive. They have ignored court summon entirely. They either failed to file a memorandum of appearance within 15 days or failed to file the statement of defense within 14 days. Appearance is normally within 15 days. The statement of defense within 14 days. Thus, if you look at those two sentences on the conduct of defendant, it helps us to differentiate between summary and default judgment. I rest my case.
I think we'll find an issue that requires a bit more research. I'll go and look deeply into it. Apart from section 36, apart from apart from order 36, rule 1, apart from order 36, any other foundation we have to assume that it is a result of the plaintiff and not the defendant. Because I was thinking, the way that you have explained it, that summary judgment will be given where a defendant, although present, has not played a role that is good enough to challenge the. But I tend to think that it can happen where the defendant has filed the pleadings that are necessary, but where on the face of it, it appears that this person has got no sufficient. They don't have sufficient ground to challenge the claim that is before them. And then when the defendant cannot challenge sufficiently the claim that is before them, summary judgment can be entered, and it means that the court has considered both pleadings and now they are reaching the summary judgment.
Is it not what we have talked? Kasham, yes? So that we move to the next. Is that not what we have just discussed here?
There's a point that I'm trying to. Is it really a matter of the plaintiff? That is what is troubling me, and I'm going to. We are going to look into it. I've noted that down. I've noted that down. So we need a bit more. We need more legal authority on that, and then we'll settle it. Because I tend to think that the defendant can also apply for summary judgment. Although those are just my thoughts. Victor, Garuya, you want to say something?
Yes, but I will not delve so much. Kashem, now your point. You tend to make it look like the defendant is now attacking the plaintiff.
Yes.
The first order two. There is an application where the defendant can move the court to challenge a plaint, to say that this plaint discloses no reasonable cause of action.
Yes.
But they cannot move the court to make a summary judgment. They are moving the court to use its inherent power now to strike out the plaint, not the other way.
Okay.
When unajaribu kuikoi.
Sawa tu. Wacha tuseme hii kitu. Si kesho bado tuna discuss civil procedure kesho na Friday tutairevisit when we have more facts. Sindio? So let us go to the other
Yes.
question. Let us go to the other question. And this other question, I want to Arnold, are you there?
Daniel,
Yes.
I think it's now 10 p.m.
Oh. It's 10, eh?
Cross
No.
the other side.
Oh, okay.
Yes.
Okay, I understand. So guys, I think we stop there. We give Victor an opportunity to take us through the CLE exams, and then we also try to we for 30 minutes, isn't it, Victor? I cede the floor to you.
I have a proposal. Peter, hello. Kashim,
Yes.
we had said that we give the discussion 1 hour, although we extended to 2 hours. And
Yes.
when I look at what we were talking about, is like I think we have made some very good progress. If you guys ask me, true or not true? Because we have covered how many questions? 29 questions. And 29 questions out of 35, I think is a very good progress. The question that my brother was supposed to present, I was of two opinions. If he can, because you have got 4 also questions to finish. If you can finish these questions, then tomorrow when we are fresh, we embark on the exam questions. It will help us to tie what we have learned here with the exams question. But that is my proposal. We can go straight to that so that we come here prepared that my brother is taking us through the questions and we tackle them. Because I know by the time we tackle one question, it may require even 45 minutes thinking through and what have you. But that should be an issue.
No, what you can do, because the 35 questions are not all that we have. Remember, we also mentioned that we are going to put more questions to that list. We are going to put more questions to that list so that it is going to be very long, and we can be going through it section by section. And we're not going to be through with the questions, by the way. So I think what we discussed yesterday, that we allow some time for the questions, and then 30 minutes, the last 30 minutes for CLE paper questions. I think that is going to be a good idea. If we say that we put this aside, tomorrow also we may not find enough opportunity to go through the CLE questions. I think we just proceed. We'll be doing these CLE questions as well. And we are going to add to that list. Yeah.
In agreement, yeah.
Let me not take a lot of Victor's time. Victor, I cede the floor to you.
Yes, I hope you can see what I've projected from your end.
Yes, you can be able to see.
Yes, so that's the paper for November 13th, 2025, civil litigations. And I want us we go through the first question. I sent to you earlier this paper, and I hope that you went through it. So that we can all participate this evening on what the question wants us to do. The first question has 3 parts. And the 3 questions in question 1 carries 20 marks. So I don't know if there's any person who has not read or who has all gone through the question? Through this,
I think we did okay to
yes,
refresh our mind.
yes. So she can read it for us, Elizabeth.
Yeah, I can try
Make
glasses.
it bigger. Make it bigger, please.
Ebu zoom,
Yes.
it is too small.
Can you zoom? Yeah, zoom out there. That's
Yeah,
okay.
like
That's
that.
good.
Now put it at the center.
Mhm. That's
Yes,
okay.
like
Yeah,
that.
that's okay. Yeah.
So imeanzia kutoka mwaka hima.
Yes.
Is that the starting point? Okay. Mwaka hima sued Daima Tele in Milimani High Court civil case number E304 of 2023 for special damages of Kenya shilling 35 million plus cost and interest. The plaintiff conducted the matter in person, whereas the defendant was represented by the law firm of Sheria Bora and Company Advocates, where Mr. Sheria Bora is the sole proprietor. Judgment was delivered on 8th September 2023, whereupon the court dismissed the matter with cause to Daima Tele, since, according to the court, Mwakahima failed to prove his case on a balance of probabilities. Conclusion of the matter notwithstanding, Mwakahima has taken issue with paragraph 5 of Daima Tele's statement of defense dated 4th July 2023, filed in the matter, which read as follows. The defendant avers that the plaintiff is not entitled to the sums claimed as alleged, or at all. The defendant hastens to add that the alleged sums claimed by the plaintiffs were fraudulently siphoned by the plaintiff from Mahinda Tele Company Limited, which is a separate legal entity and, in any event, has not been sued in this matter. The plaintiff is an apologetic thief, conman, and insensitive fraudster who has tormented the defendant, who is his co-director stroke shareholder in the company. Hence, the defendant is non-suited to the plaintiff. Based on the foregoing paragraph, Mwakahima filed a fresh claim as follows. That is the claim. I can read, go on, because it's the then I will read the plaint. If wako chini unaweza scroll up kidogo. One, now the plaint. The plaintiff is an adult of sound mind and disposition, a businessman based in Nyeri. The plaintiff address for purpose of this suit shall be the Nyeri Business Center, third floor, PO Box 100 Nyeri. Email address is mwakahima2023@gmail.com. Number two, the first defendant is a female adult and a businessman based in Nairobi. Number three, the second defendant is a male adult, an advocate of the High Court of Kenya and the sole proprietor of Sheria Bora and Company Advocates, whose offices are situated in Kitale. The second defendant has been sued in his individual capacity for misadvising the first plaintiff, who was his client in Milima High Court civil case number E0304 of 2023 as the defendant. Fourth, the third defendant is a limited liability company, duly incorporated as such under the Companies Act, Sub 486 of the laws of Kenya, with its registered offices in Kwale. 5. The plaintiff avers that in the first defendant's paragraph 5 of his statement of defense dated on 4th July 2023, filed in Milimani High Court civil case number E304 of 2023, the first defendant stated as follows of and concerning the plaintiff. Do I need to repeat the paragraph?
to number 6.
Number
What?
6, the plaintiff contends that the said words, either in the natural or ordinary meaning, were meant or understood to mean that the plaintiff, 1, is a thief, 2, is a conman, 3, is fraudulent, 4, is dishonest, 5, leaves off dishonest activities, and 6, is untrustworthy and cannot be anyone's co-director stroke shareholder. 7. By the first defendant's conduct aforestated, the plaintiff has been subjected to ridicule and his reputation has been lowered in the eyes of the right-thinking members of the society. The plaintiff further avers that initially he was a successful businessman in Nyeri and beyond, but upon the first defendant's huge paragraph, his businesses have suffered and he has lost a string of clientele. 9. There is no other suit pending between the parties herein. 10. Reasons wherefore the plaintiff pays for A. Kenya shilling 10 million for special damages for defamation, dated at Nyeri this 3rd September 2025. I think that is it because the other part is drawn by Mwakahima. That is it. So all the defendants have approached you to enter appearance on their behalf and defend them in the matter. So question A, analyze the claims as drawn and advise the client on the defects thereto. B, upon entering appearance and filing the statement of defense, you raised a notice of preliminary objection, which was upheld by the court, assuming you were the presiding judge. Draft the decision. And C, the additional information that you were given by your client when you were talking, while you were taking instructions, is that upon filing the matter, Mwakahima called Daimatele's estranged wife and maliciously effected service of the pleadings and summons to enter appearance on her so that Daimatele does not come to learn of the proceedings. For Sheria Bora, he effected court process on the Law Society of Kenya, headquarters in Nairobi. He later caused an advert to be published in the Daily Nation, notifying the company of the existence of the proceeding. Advise your client whether or not Mwakahima followed the right procedure. Thank you. That is the question.
Yes, thank you for reading that. I want us to discuss, we start with the first question, which requires the substantive and procedural defects as raised in question 1. So, according to my research, I found 6 procedural defects to that question. I take you through them, then we summarize together after whatever you think. 1, the first defect in that case is the issue of jurisdiction, in that this suit has been inserted before the ALC court. The ALC court in Nyeri. So if you look at the complaint, that part, after the Republic of Kenya, the Environment and Land Court at Nyeri raises the first defect in that the plaintiff claim is founded on alleged defamatory statement contained in the pleading file in that court, that is A0304 of 2023. So go to Article 162 2B of the Constitution, that article donates the jurisdiction of the ELC. Also, the ELC Act restricts the court to disputes relating to the environment, occupation, use, and the title land. That's under Section 13, Subsection 1 and 2. So the present dispute concerns the dot of information. So this falls under the civil jurisdiction of the High Court. So in this case, and
What?
yes,
Hi. I have a suggestion. Unaona hiyo maswali because you have already done your research and have the answers. Then you say you have the answers. Could you maybe we discuss so that people give the answers, and then now after we've discussed and see, after we identify, we can now come and say this was the answer or this is what you put in your research.
Fine. So let me finish the first one of the debate, then we do what you said. So what I was saying is that in this case, the court lacked jurisdiction to entertain this matter. And remember that jurisdiction is everything. Without jurisdiction, it has no power to make anything or to make any step. That was evident in the case of the owners of motor vessel Lillian versus Caltex Oil K Limited. So maybe, Madam, I can start with you. You raise your substantive and procedural defects which you might have seen while reading.
Okay. I heard I saw that was the issue of jurisdiction, and to be very specific, one pecuniary jurisdiction, because like when we were talking with when we were doing this issue of jurisdiction, the issue of pecuniary, there was different types of jurisdiction. So for me, I noticed that one. Yeah, but I don't want to repeat what you have said.
We also have Muricha. Is Muricha around?
Jurisdiction, no. The territorial is the case where it's supposed to be filed, rather the territorial jurisdiction or the boundaries within which that court operates. And I also uphold that pecuniary jurisdiction of that subject matter, because the other matter is not determined. The liquidated damages are not quantified so far.
Okay, clear. Then. Is clear around? Okay, fine, yeah, okay. We move to Charles Mugunde.
Yes, before I go further to the plaintiff, I see that the respondents, we have strangers here.
Okay, somebody was saying the same will apply to service.
We have strangers in the accused. And also, when we have the petitioner, it must go with the first respondent to the accused. Accused is now a criminal case, and now that we are saying it's a civil case. There's a contradiction again here. the parties accused one, accused the second, the third, those are not supposed to be, if we assume that it's under the right jurisdiction, but which is not, if it was, these are not the accused because these accused are found in criminal matters and not in this civil case. Again, the suit they're saying is a petition. This one does not fall under petition. So the description of parties is
Daniel,
I dropped out a bit. My internet is misbehaving here, so I lost a bit of context. What was the question? If you can remind me.
we are looking at that claims which are projected. Then the first question is we analyze the claim as drawn and advise us on this exact. And subsequently question earlier today in the morning.
Oh, you sent them in the group, eh? Yeah, I saw, but I just let me just access the group now and check the question. This is
25
Okay, let me just check the question from the group and respond.
Yes, meanwhile we move to Ngaruya. Yes.
Oh, I wanted to just add, those who are accused, I'm seeing here, sorry, she's called, apart from the fact that the parties are incorrect, here, Shiabora is not an accused. Yeah.
So that's another difference.
Because Shiabora is here in Wake. The lawyer or the advocate, that is. So the advocate cannot be an accused.
Okay.
Yeah.
Yes, I can say when it comes to the prayers, he has claimed 10,000 being special damages for defamation. That is not the prayer to seek for defamatory claims. And also, if
Sorry,
you
I want
look
to
at paragraph 6.
clarify that, Mr. You have said 10?
Paragraph 10A. He's seeking special damages for defamation. I believe defamation is awarded general damages as compared to special damages. Special damages are the provable damages with receipts that you incurred when it comes to road traffic accident, but it is subject to discussion. But the major point that I had was on paragraph 6. He has just listed the particulars without any explanation or proof, because the procedure, the law of procedure, civil procedure requires that you need to prove any fraud that you claim has occurred. Yes. Thanks.
Now
A footnote as that of Mr. Ngaruya is that you cannot on demand letter quantify what amount to be awarded as damages, because this one is supposed to be assessed by the special reports and of the court findings. The court are the ones which have jurisdictions now to determine how much special damages to award to such a certain client. Like in that case of Omari, can be awarded 50 million for defamation. That one, the court has judicial notice of that, or of a person of such stature in the society. Thank you.
Now, where we come to Arnold.
I think most of the issues have been talked about. What I was not sure, I think it has been mentioned about the issues of the kind of appeal that he's making. We talking about negligence? Are we talking about what? Are we talking of defamation? Are we talking about? I think there is a lot of mix between whether it's a negligent case, whether it is a tort, defamation, or whether it's a civil matter that has been mentioned. I had looked at that. I think I also noted the issues of the subject matter jurisdiction. I don't know whether. I think I've also noted that quote. I've gotten the answer that I wanted. There is the issues of mad letter. Civil matters, when you send a mad letter, it helps you able to argue out the damages that you are seeking. That's what I wanted to say. Thank you.
And where then we move to Gary.
Okay, from analysis from this about the defamation, since the name Mwakaima, statement was made on 4th July 2023, we can see Mwakaima filed the complaint at September 2025. And the information cases, there are of 12 years. You can tell 12 months. And again, information telling about cases, you can't, okay, after 12 months, you can't leave out of time or out of Nini court so that you say you're out of time, you can't seek leave in defamation. So, it's a matter of struck out on the issues of meaning out of time.
Excuse, just a quick one. None of your issue finding out of time. It's valid, but it's like we're looking at the structure procedure used this. We are not looking at this issue. We are looking at the errors. I think your answer is correct, but if it's a valid issue, but now you have been the question we're answering. So the legal issues or the legal defects, but rather it's the structure. Kama hiyo mambo ya practice, kama hiyo mambo ya that those jurisdiction, pecuniary and whatnot, and also the type of whether it's the person say it's a petitioner, also such things. I don't know, but that's what I'm thinking.
Yes, we are looking at the structure of that plane.
Yes.
The errors which have been found in the plane has been omitted. Not the procedures, but the errors plane itself. We move to Garuya.
Yes.
Yes, Victor Garuya.
Yes, my other point was that as we address this question, we should also take note that the examiner knew the students will not read through the plaint itself because they have deliberately used a plaint that raises no cause of action. Because if you look at the context of how this defamation arises, it arises from a court pleading, of which a court pleading is a defamatory claim cannot arise in a court document that is in the public domain. So the examiner also expected that some students will just ignore the question and they will just look at the general outlook of the document. That is a rider there. So the plaint discloses no cause of action.
Okay, I don't know if there's another want to speak on the first question on the defect before I give the summary whatever I found. So I don't know if Daniel is ready, then move to Stephen.
I'm just going through the question right now, and
Okay.
you can just proceed, or you can give the chat to Steven.
Yes. All right.
I think I've contributed. Wanted to contribute. Go ahead.
Okay. Now, apart from the issue you read it, the second fact is solid privileges, whereby adds complaint of or contained statement of defense in judicial proceedings. Remember, the statement of judicial proceedings are protected by this of absolute privilege, which provides they are to the issues before the court. So whatever statement it was as noted in paragraph 5, those are absolute privilege and they lack cause of action for defamation. So the third one was on the misgender of in that defender
Please.
is an advocate who was merely for presenting the defendant in the act proceeding. Looking at other rules, which has this question of the parties. That one is defective pleadings. We have raised that, not necessarily captured in order 2.1. He said the pleading properly refer to parties as partners and accused. The proper parties have been left as plaintiff and defendant. So, defective pleadings, which is contrary to the 251, render the pleading incompetent and embarrassing. So, this raised the issue of failure to particular damages. That then failure to plead malice, we have raised that. Order to now we can move to number two.
Sorry, that question has how many marks? 80 marks.
Yes,
You
and
have
before we have
different kind of receive. Then the second question,
how many?
should succeed,
1,
the suit
3,
struck out with cause
4,
for want
5,
of jurisdiction and
6,
because the pleaded claims High Court at Yale appear
10.
and the competence of the state continue on the face of the plaint. Plaint is expressly founded on alleged defamatory words contained in paragraph 5 of
was
the
that supposed
this court's jurisdiction,
point
especially before a court without jurisdiction court be struck out. The plaintiff
Sometimes if you can try to maximize, I don't know how they times you expect it without necessarily by the time you write point. I don't know. I think it's for explain the consensus we can use, I don't know. Not here for harmonies, okay?
yeah,
As much as you not listed the number points you put, I think this when to section that you exhaust them once you should be able to already consulted. You should you brief the that you have, and then you'll have an opportunity to and pull up the difficult noise.
Yes, I think I have the one in the group.
Okay.
In summary, that Facebook not defend have privileges, gender equality, also right defend leading, social changes, and plead. I write the six with supporting provision.
I think the other one you can talk about is we have said, particular special languages, but in the case of tort, to that agree, the commissions, in case of commission here, be able to must new case damages in case of defamation be able to quantify this.
It's a with damages.
That's a point.
Clarification. Okay, I'm just asking. People taxing IT companies have it. Can that be actual?
I think can actually also part of
Company.
Can as verified that we strive for scientific verifying habit.
yeah, that's a good point. But I think for us to take future, just whatever you are right. Then also something I would by is that we are right when we like you see those and you mark don't the point at you can to like on a dot that that unafanya kama moja but two. So to be safe unaandika in prose form. I was advised that
Writing short, you're writing short paragraph.
yes, short paragraph. Lakini usiweke indication like thing in indicate for people know. Just in paragraph and make to of code what which are the mark can have point like mark like what
But now on that note, I think we have it has been effect there. Right that in the matter of this matter, but in matter of
we can read that first of all someone talk about back, right? By you know, you move not using But because already we have you can be I if it has be will question, but you to define it. But then again, another thing is that so that about argument by go because there's that action you uh, was a whole matter that has been decided and anything is ready you can say because it's ready the part like time with you you get so can say that you know me I don't think it was and um, I the speaker also pre that so I think all of those things is important and I think discussing is like answering E B we have been in B that pre which will allow us so things is the that effect that it's a naked that the uh, to Nini Judah it's a naked link equal traffic and part as the or the or the our the just thing outside the boundary of in quality of previous
that yeah. Okay. See, Oliver is that so don't know question project for implementation. Must then
but what they did very valid uh, the true violence.
Oliver yes
in elements of hearing again whether that or is I think we have the head mistakes that just repeating what we were saying. The particulars a friend also said about the cost of working life. Again, of next yeah, and that application could is there because I don't see anything in no documents on that quality.
So, sorry, I think is an uh, allow to I get what she did. I think he was finalizing on the point last. So just allow to be forward.
Well, the two again 11 years is the share the that is you see one again start with even yes question is can be when you play charge at what to
Under Order 2, Rule 15 of the Civil Procedure Rules, the following are the orders. The notice of preliminary objection is upheld. The plate dated that fits in an exam ruling is not an order of the court. So be keen. Then the examiner will not have a look at your ruling because it's in an examination situation and you fail to incorporate your signature. Then the examiner will not have a look at your ruling because an unsigned ruling is not an order of the court. So be keen. Advise your clients whether or not then advise your clients whether or
permit not the think this
Sabbath
Oh, actually, I was in that. That's very helpful as you are guiding and others the very far before after or to attend the issue that's the the things that to defend position or um, also or action. So I so we can actually even say SWOT those are
Okay, I also had some comments. In this question, now the examiner is expecting to see the structure of how a decision will appear. Remember to use the FIRAC rule, case title, then how the parties moved the court accordingly, brief facts. You have considered both sides. You're now making you're narrowing down to the main issue before the court. Then you make a determination on that issue, then you make a conclusion, and then the examiner is also expecting to see whether you have signed, because I heard that for students who never signed that decision, you are violating one of the greatest principle of decision making in Kenya. Yeah, so they suffered greatly. I heard that they scored 3 out of the 6 marks.
and is that out that is
cover utterance up to person and thereafter investigation is allowed to be carried out. Preliminary actions are now there some issues
case.
Preliminary objection for our revision, but if it were an exam scenario, we would draft the judgment, because the question is assuming that the presiding judge draft the decision. So decision, you're drafting it in someone is saying that we're supposed to, it's the ruling, not the judgment.
When you are not acting, you are acting with the bias without, out of law now.
Yeah. I think I want to rest my case.
I think I can do. I think see,
accommodated. What you can
Well,